Ladies and gentlemen, good morning. Welcome to the Hcch Conventions Supporting Transnational Litigation in Civil or Commercial Matters, a workshop to celebrate the 10th anniversary of the Regional Office for Asia and the Pacific, organized by Hcch. A very warm welcome to all the participants joining this workshop, both in person and also online. My name is Vinci, the MC for today. And now, I would like to invite Levi Gao, Legal Officer of Hcch Regional Office for Asia and the Pacific on secondment, to introduce and moderate the opening section for us. Levi, please.
Thank you, Vinci. Excellencies, ladies and gentlemen, Hcch Regional Office for Asia and Pacific, ROAP, has been promoting membership of the Hague Conference and accession of its conventions since its establishment 10 years ago. Under the direction of the Permanent Bureau, the ROAP aspires to be and has demonstrated its capability of being a regional hub that fosters cooperation among the countries in the region and between the region and the rest of the world on vital cross-border civil and commercial legal matters. We are extremely grateful to the Central Government of China and the Hong Kong SAR government for their long-standing support. Now, let me invite our honorable guests of our workshop to proceed on the stage. Mr. Liu Guangyuan, Commissioner, the Commissioner Office of Ministry of Foreign Affairs of People's Republic of China in the Hong Kong SAR. Mr. Lin Dingguo Paul, SBS SCJP, Secretary for Justice, the Government of the Hong Kong SAR of the People's Republic of China. Dr. Christophe Bernasconi, Secretary General, Hcch. Please smile to the camera. I would like to invite the guests to join together on the stage for group photo session. Mr. Chen Guokun, SBS JP, Deputy Secretary for Justice, the Government of Hong Kong SAR of the Republic of China. Professor Zhao Yun, Representative, Hcch, Regional Office for Asia and the Pacific. Mr. Adrian Lai, JP, Deputy Secretary General and co-convener of the Advisory Board, AAIL, and Barrister, DVC. Dr. James Ding, Law Officer, Deputy of Justice, the Government of Hong Kong SAR of the People's Republic of China, and Chair APAC Economic Committee. Mr. Khalifo Tavares, Principal Government Counsel, Legal Enhancement and Development Office, Department of Justice, the Government of Hong Kong SAR of the People's Republic of China. Please smile to the camera. I would like to invite all the guests on the stage to be seated, please. Most grateful if His Excellency Mr. Liu Guangyuan will stay on the stage for the preparation of the opening remarks. Thank you. Now it's my great honor to first invite Mr. Liu Guangyuan, Commissioner, the Commissioner Office for Ministry of Foreign Affairs of the People's Republic of China in Hong Kong SAR to deliver the opening remarks. Listen to, please.
Justice Secretary Mr. Paul Lam, Secretary General Dr. Bernasconi, Professor Zhao, distinguished guests, friends and colleagues, ladies and gentlemen, good morning. It gives me great pleasure to join you in this lovely season tinted with autumn hues to celebrate the 10th anniversary of the Regional Office for Asia and the Pacific of the Hague Conference on Private International Law. On behalf of the Commissioner's Office of the Chinese Foreign Ministry in Hong Kong, I offer my sincere congratulations. As the most influential intergovernmental organization in the field of private international law, the Hague Conference plays a key role in the unification of private international law, international people-to-people exchanges, and in economic and trade cooperation. Since being its member in 1987, China has been fully supporting the Hague Conference. We have fulfilled our international obligations under the convention we acceded. We have also contributed the Chinese wisdom to the rules-making of the private international law by taking an active part in relevant convention negotiations. A decade ago, with the efforts of the Permanent Bureau of the Hague Conference and the Chinese side, the Regional Office for Asia and the Pacific was established in Hong Kong. Over these 10 years, the Chinese government, including the governments of Hong Kong and Macau SARs, has provided a strong support for the operation of the Regional Office. The Regional Office has also lived up to the expectations by making best use of Hong Kong's location edge to organize international seminars and cooperate closely with regional countries. The Hague Conference has thus enjoyed a bigger influence, deeper recognition, and wider participation across Asia-Pacific region. This testifies that setting up the regional office in Hong Kong is the right choice. Ladies and gentlemen, over the past 10 years, the regional office based in Hong Kong and rooted in China has witnessed the vitality of the practice of one country, two systems. The great changes of Hong Kong in the new era and a historic leap in China's relations with the world. For Hong Kong, the past decade is a journey of perseverance and renewal. With the support of the motherland, Hong Kong has achieved greater development and under one country, two systems, which is evidenced by its strong economy, solid status as a global financial, shipping, and trading center, booming innovation, and high-tech industries, and also its leading freedom and open index. World-class business environment and distinctive advantages of the common law. Years ago, in the face of turbulent developments in Hong Kong, the central government exercised its overall jurisdiction over the SAR as prescribed by China's constitution and the basic law of Hong Kong SAR. The national security law was formulated and put into effect. the principle of patriots administering Hong Kong was implemented. Thanks to these measures, Hong Kong has achieved the major transition from chaos to stability. Today, Hong Kong is reborn with vigor and vitality. Under the leadership of the new SAR government, Hong Kong is speeding up its integration into national development, aligning itself with national strategies and expanding external cooperation. More emphasis has been placed on economic development, people's livelihood, and social stability. A new chapter of good governance has opened. For China, the past decade is a journey of progress and peace. Through dedicated efforts over generations, Chinese people have achieved moderate prosperity. The millennium-old dream of the Chinese nation, about 100 million rural people have been lifted out of poverty, making the victory in the largest battle against poverty in human history. We have put forward and applied a new development philosophy, work hard to promote high-quality development, and pushed to foster a new pattern of development, contributing to a historic rise in China's economic strength. We have built the largest education, social security, and health care systems in the world, bringing about an all-round improvement in people's lives. We have developed whole process people's democracy, reinforced the foundation that ensure people's running of the country, injected vitality into democracy at a community level, and provided better protections for human rights. We have also acted on the principle that lucid water and lush mountains are invaluable assets, and promoted green, circular, and low-carbon development. This has led to comprehensive changes in China's ecological protection and brought us blue skies, greener mountains, and cleaner waters. For the world, the past decade is a journey of deep integration with China and shared development. China values peace, development, cooperation, and mutual benefit. We have both safeguarded and contributed to world peace and global development as we pursue our own development. In the past decade, China has contributed 38.6% on average to global growth, serving as a key engine and a stabilizer of the global growth. We have pursued a more proactive strategy of opening up, worked to build a global network of high-standard free trade zones, and made the Belt and Road Initiative a popular public good and cooperation platform welcomed by the international community. China has become a major trading partner for more than 140 countries and regions. It leads the world in total volume of trade in goods and is building a broad pattern of opening up across more areas and in greater depth. China pursues major country diplomacy with Chinese characteristics. We have promoted the building of human community with a shared future, played an active role in the reform and development of the global governance system, deeply engaged in international cooperation against COVID-19. Through these efforts, we have won widespread international recognition. Facts have proved time and again that China's development is not only good for itself, but also provides new opportunities for the world. Ladies and gentlemen, the 20th National Congress of the Communist Party of China has mapped out a blueprint for advancing great rejuvenation of the Chinese nation through Chinese modernization. The Chinese people, including our compatriots in Hong Kong, are forging ahead with enterprise and fortitude to build a modern socialist country in all respects. Standing at a historical juncture, we are full of confidence. With the support of the motherland, Hong Kong will be able to give better play to its unique standards and advantages and create more glories. As China embarks on a new journey and the Hong Kong SAR starts a new chapter, international legal organizations in Hong Kong will have much to contribute and much to gain. Looking ahead, we believe that Hong Kong office will continue to play the role as a window of the Hague Conference in Asia Pacific and conduct closer cooperation with member states in the region. It will help enhance the influence of the Hague Conference and facilitate the research and the development of private international law on a global scale. China, as a host country, will further participate in and support the work of Hong Kong office. We will also join hands with other countries and international organizations, including the Hague Conference, to shoulder our responsibility of our times and share in opportunities of development together, and make peace developments no longer a luxury, but a necessity shared by all. Thank you so much.
Thank you so much, Mr. Liu. Please be seated. Now, may I invite SJ Mr. Paul Lam to deliver the opening remarks. SJ Mr. Paul Lam, please.
Commissioner Liu, Dr. Bernasconi, Professor Chow, Consul General, distinguished guests, ladies and gentlemen. It's my pleasure to welcome you all to the workshop in celebration of the 10th anniversary of the Hague Conference on Private International Law Regional Office for Asia and Pacific in Hong Kong. What makes this occasion even more special is that this year, 2022, marks the 20th anniversary of the establishment of the Hong Kong Special Administrative Region, which we are celebrating throughout the Hong Kong Legal Week. I hope you will all enjoy the wonderful events that we have organized for you. The Hague Conference has been our long-standing partner for the past 25 years. With the strong support of our Central People's Government, Hong Kong has been participating actively as part of a Chinese delegation in the work of the Hague Conference since 1997. This is made possible by Article 152 of the Basic Law, which provides that representatives of the government of the Hong Kong SAR may, as member of the delegation of China, participate in international organizations or conferences in appropriate fields limited to stays in usual circumstances. In fact, a colleague from the Department of Justice, as a delegate from China, was also elected as the chair of a special commission and a working group in relation to Apostolic Convention some years ago. Our participation in the Hague Conference is one of the best illustrations of the successful implementation of the principle of one country, two systems in the past 25 years. In addition to regular participation in the meetings of the Hague Conference, the Memorandum of Understanding for the technical arrangement relating to the secondment of legal professionals between Hague Conference and Hong Kong SAR in 2020 further cements our partnership. Through the secondment program, our local legal talent will be able to broaden their horizons through learning from international legal experts and inject a Hong Kong perspective in shaping the development of international law. Our sincere gratitude goes to the Central People's Government for their staunch support in all these initiatives. The strong support by the Central People's Government for our legal system was also reiterated by President Xi in a speech delivered on the 1st of July this year, which marks the 20th anniversary of the establishment of the Hong Kong SAR. It's still clear that the principle of one country, two systems is a long-term policy that must be adhered to in the long run. He expressed support for the maintenance of the common law system in the Hong Kong SAR. This means that Hong Kong will continue to be a common law jurisdiction and the only common law jurisdiction in China. Despite the differences in the legal system between Hong Kong SAR and the mainland, these two jurisdictions have developed various mutual legal assistance arrangements, some of which are in fact modeled on the Hague Conventions, such as the Hague Service Convention, the Hague Evidence Convention, and the Hague Choice of Court Convention, which are all exemplary models for bridging different legal systems. Most recently, we have drawn references from the Hague Judgment Convention in formulating our arrangement with the mainland on reciprocal recognition and enforcement of judgment, the REJ arrangement. Our colleagues handling the REJ project took part in the special commission meeting and a diplomatic session relating to the Hague Judgment project and gained very useful insight from there. The REJ arrangement and its implementing legislation, namely the mainland judgment in civil and commercial matters, reciprocal enforcement ordinance, provide a straightforward registration mechanism for the enforcement of mainland judgment in Hong Kong with sufficient safeguards reflecting the existing common law principles and also international standards. They would better protect parties' interests and enhance certainty and predictability of cross-border enforceability of the relevant applicable judgments. It would in turn improve the environment for cross-border trade and investment and enhance our competitiveness as a regional legal and dispute resolution service center. Taking into account the practical needs and circumstances of the Hong Kong SAR and the mainland, and fully utilizing the unique strength of one country, two systems, we have gone even further than the Hague Judgment Convention by covering a wide range of judgment on contractual and tortious disputes, including judgment given in respect of certain type of intellectual property rights. This is a very strong testimony to the vitality and unique advantage of one country, two systems. Ladies and gentlemen, we now live in a very interconnected world where the work of Hague Conference is even more relevant than ever. Our globalized economy, with multiplying cross-border transactions and rapid mobility of people as its hallmarks, demands a well-developed and harmonized private international law regime. As an Asia metropolis accommodating worldwide talents, trade, and capital, the Hong Kong SAR shares Hague Conference vision in the development and promotion of private international law, which contributes to the global common good. In this connection, I must mention the focus of our celebration today, the regional office. Hague Conference only regional office in the Asia-Pacific region. It has been established in Hong Kong since 2012. With its strategic geographical position in Asia and the Pacific, Hong Kong is well positioned to connect with the rest of the world and is the major gateway to mainland China. It is our honor to host the regional office, which is housed in the Hong Kong Legal Hub at the heart of our city. The regional office forges a perfect synergy with Hong Kong in raising the visibility and profile of Hague Conference and promoting the Hague Conventions in the region. I must also commend the outstanding contribution by representatives of the regional office in the past 10 years, in particular the current representative, Professor Zhao Yun, who has overcome many challenges and disruption caused by the pandemic in order to advance the work of the regional office over the past few years. For instance, my department worked with the regional office to strengthen collaboration with regional organizations, including the Asia-Pacific Economic Cooperation, APEC, by renewing the accredited guest status of Hague Conference under the APEC Economic Committee in order to promote awareness and use of private international law instrument by APEC economies. In addition to the collaboration under APEC, the Hong Kong SAR government has started the process to join the Regional Comprehensive Economic Partnership, the RCEP, the world's largest free trade area, which has commenced on the 1st of January 2012. A robust private international law regime will undoubtedly facilitate the envisaged growth in the region. I'm very confident that we are ready to set sail together to the promising future in the Asia-Pacific and under the Belt and Road Initiative. As the leading center for international legal and dispute resolution services in the Asia-Pacific region, Hong Kong is very privileged to host this workshop. We are privileged to have invited eminent speakers to this workshop to discuss how the Hague Conventions facilitate the full life cycle of transnational litigation, from jurisdiction and choice of court issues, service process, taking of evidence, document authentication, to recognition and enforcement of foreign judgment, which all contribute to effective access to justice, cross-border cooperation, and development in the Asia and the Pacific region. This workshop is part of the regional office's admirable endeavors made possible with the aid of technology, the resilience of our city, and above all, your, and of course, the Central People's Government's staunch support. We will continue to give our full backing to Hague Conference work, notably through the regional office in the progressive unification of the rules of private international law. On this note, may I wish this workshop every success. Thank you very much.
Thank you, SJ Mr. Paul Lam. Now, it would be my great privilege to invite Dr. Christophe Bonasconi, Secretary General, Hcch, to deliver the opening remarks. Please.
Honorable Commissioner Liu, Honorable Secretary for Justice Lam, Professor Zhao, I am delighted. I'm delighted to be here with all of you, Excellencies, dear friends and colleagues, also those online, and I understand there are many of us following this event online. But I'm delighted to be here to celebrate the 10th anniversary of our regional office for Asia and the Pacific, ROAP as we call it, with you all. I'm delighted that this event takes place as part of the Hong Kong 2022 Legal Week. And I'm also very delighted to share some news that I got yesterday and which I checked with Secretary Lam earlier this morning if I can share it with you, and he gave me his permission to do so. But yesterday our office received a note verbal from the Embassy of the People's Republic of China in The Hague, confirming a further financial contribution to the regional office for a further 3 years. I am immensely grateful to the central government of the People's Republic of China, to the government of the Hong Kong SAR for this strong, continuing support. Thank you very much indeed. I would also like to thank all the supporting organizations that make today's event possible: the Asian Academy of International Law, the Hong Kong Bar Association, Law Asia, the Law Society of Hong Kong, and Invest Hong Kong. Thank you for your contribution. 10 years ago, the HCCH, with the strong and indeed key support of the government of the People's Republic of China and further initial support of Australia, opened its second regional office, a few years after it had opened its first one in Buenos Aires for Latin America and the Caribbean. ROAP here in Hong Kong serves as a bridge to strengthen the link between the Permanent Bureau in The Hague and countries in Asia and the Pacific region. Looking back to the first decade of ROAP, we can say with confidence and pride that ROAP is a success, that it is accomplishing its main mission and objectives as envisaged as its inception, namely to increase not only the visibility of the HCCH and its work in this vast region, but also the awareness of its importance and relevance for the region. ROAP is making a difference. The interest in the work of the HCCH from the Asia-Pacific region has intensified in recent years, both in terms of new members of the HCCH from the region and the number of states joining HCCH conventions. From the Asian sub-region that actually falls within the active remit of ROAP, Vietnam and Singapore became members of the HCCH soon after the opening of ROAP, followed in 2021 by Thailand and Mongolia. And in terms of treaty actions, in the last 2 years only, the Philippines ratified the Child Support Convention, and Indonesia and Singapore both acceded to the Apostille Convention. We will hear more about ROAP's achievements from my colleague, Professor Yun Chao, the representative of ROAP. As mentioned by Secretary Lam, the HCCH conventions enhance access to justice, effective access to justice. In this way, the conventions also facilitate cross-border trade and commerce, encourage foreign direct investment, and support individuals, families, and commercial operators in an international context. More specifically, as you will hear from our distinguished speakers in the 2 panels today, the HCCH has a package of conventions that support transnational litigation in civil or commercial matters, covering a broad range of aspects relating to dispute resolution, from choice of court to the transmission of documents for service of process or the taking of evidence abroad, to non-discriminatory access to justice, all the way to the recognition and enforcement of foreign judgments. And our work in this field is further expanding as we explore how to deal with parallel proceedings. Finally, all this work is of course complemented by the ever-important Apostille Convention, not only the HCCH Convention with the highest number of contracting parties, currently 124, but also by far the most widely used of all of our conventions. In a world that keeps evolving, it is critical for all countries, including the countries in this region, to engage with the cooperative, global, private international law order that is encapsulated by the HCCH. The HCCH offers a comprehensive suite of legal cooperation and transnational litigation instruments that can support countries in their efforts toward sustainable economic development. Now, the important thing in relation to the work of a regional office is to realize that conventions that apply and operate properly in a region produce benefits not just for that region, but indeed for all contracting parties in all parts of the world. If you are based, say, in Europe or the Americas, you also have an interest in seeing a convention apply and operate well in Asia if you need to rely on that convention. Which is why I always say that the work of our regional offices produce a win-win, and that all contracting parties, and indeed all members of the HCCH, benefit from the work of a regional office. Today, the HCCH has 91 members and 65 non-members that are connected to the HCCH by being a party to at least one of our conventions. The HCCH thus represents a global network of currently 156 connected states or parties in every geographic region and category of economic development. This work of HCCH members and contracting parties is an asset for countries in the Asia-Pacific region pursuing a common goal of furthering the region's global engagement. Thus, being a party to an HCCH convention gives the state access to this far-reaching and interconnected network where the same private international law rules and legal cooperation framework apply. I would like to conclude by highlighting again the generous and continuing contributions from both the central government of the PRC and the Hong Kong SAR towards RoUP throughout the past 10 years. We are most grateful indeed for the DOJ's voluntary contributions that enable RoUP to exist, to operate, and to make a difference. I would also like to take this opportunity to thank our RoUP colleagues, our faithful office manager, Alex Ng, who has been with RoUP since the very beginning. The secondees from Beijing, currently Mr. Levi Gao, the many interns from the region, and of course, in particular, our former and current representatives. Judge Hartmann, who put RoUP on track back then, Professor Anselmo Reyes and former Solicitor General Frank Poon, who both strengthened and developed RoUP's impact in the region, and Professor Yun Chao, who continues to make significant and important efforts to further enlarge the footprint of RoUP, including in challenging times. The contributions and achievements of our representatives are all the more impressive as they all worked on a mere part-time basis. And yet, all these efforts have made RoUP a well-established and well-recognized office in the region, one that greatly supports the HCCH in pursuing its strategic mission towards meaningful universality and inclusiveness. Thank you all again. And on that note, I thank you all for your attention and wish you a productive and interesting workshop. Thank you very much.
Thank you so much for all your inspiring remarks. Now, may I invite Professor Zhao Yun, representative HCCH RoUP, to deliver the speech to introduce the milestones in the past 10 years and future prospects of RoUP. Professor Zhao, please.
Honorable Commissioner Liu Guanyuan, Honorable Secretary for Justice Paul Lam, Honorable Secretary General Christopher Bernasconi, Excellencies, ladies and gentlemen, it is a great pleasure for me to speak on this very important occasion. At last year's CGAP meeting, I had extensive exchanges with a number of distinguished attendees and stated that despite the pandemic, the many regional conferences hosted in Hong Kong SAR was a great success. This will continue in the year of 2022. Today, we gather here to commemorate the 10th anniversary of the regional office. As representative of the regional office of the HCCH, I'm very happy to speak on this occasion to reflect on what we have done, our past achievements, continuing advancement, and future aspirations. It is self-evident that the Asia-Pacific region is vital to the HCCH. Since the year of 2000, 44 new members joined the HCCH, with 16 of them from our region. This sum is quite astounding, and the growth potential here can be underestimated. Further exploration will be needed to look into the role of ROAP and what the ROAP can be done. From 2012 to 2022, the number of HCCH members increased from 72 to 91, with a major contribution from the Asia-Pacific region. Vietnam, Singapore, Kazakhstan, Uzbekistan, Thailand, and Mongolia are just a few examples in the past few years who joined the HCCH from our region. Despite the geographical proximity, they represent a vast range of cultural and legal traditions. The HCCH Convention seeks to bridge diverse cultural and legal traditions and offer a viable framework for cooperation between countries within the region and with those beyond the region. This is a context in which the regional office was conceived. A primary purpose of the regional office is to promote the HCCH and its conventions by increasing awareness of the value of member states and significance of the HCCH conventions. During these 10 years, our colleagues have excellent contributions. They have put in a lot of efforts, made substantial contributions, and attained numerous satisfying accomplishments. Numerous intriguing ideas and initiatives have been developed and distributed. All these contribute to the ongoing growth of the HCCH and deepen the regional link. Now allow me to present some landmarks and defining moments of the ROAP's evolution during the past 10 years. As our Secretary General has just mentioned, it's rather important to see the birth of the regional office in 2012, which was endorsed in the Council on General Affairs and Policy. Soon afterwards, we have quite a lot of conferences that was organized, including the Asia-Pacific conferences in 2014 and 2015. In 2017, the Asia-Pacific Week was held in the Republic of Korea. In cooperation with the Ministry of Justice and the Supreme Court of Korea, the symposium was to commemorate the 20th anniversary of the Republic of Korea's membership to the HCCH. The Global Forum was held in the same year in Wuhan University, organized by the Ministry of Foreign Affairs of the People's Republic of China and Chinese Society of Private International Law to commemorate China's 30 years of membership to the HCCH. In 2018, a global conference was held to commemorate the 125th anniversary of the HCCH in Hong Kong. The conference discussed the opportunities for and challenges to private international law, as well as the evolution of HCCH. Again, 1 year later, we have a major conference to promote the Judgment Convention, which was adopted in the same year in Hong Kong. I would particularly mention it's very important that the informal working group meeting was held also in Hong Kong. In 2020, due to the outbreak of pandemic, most events were held online, but even during this period of time, a lot of webinars, conferences was held to discuss various aspects of the Hcch conventions, including the conventions regarding service of documents and also evidence convention. In 2021, LOAP hosted a virtual event in September on the theme of the Child Protection Convention. And then we also talk about the EAPP program, Electronic Apostille Program. As the SJ has just mentioned, in the same year, we have signed a very important memorandum of understanding for the secondment of legal professionals to the Hcch. Afterwards, we also have attended several very important conferences organized by various international organizations, including the ASEAN and also the ILCO. Due to the time constraints, I can only touch upon a few of the highlights, but more importantly, we should look to the future. After a decade of success in the region, I'm very delighted with the office's ongoing efforts and effectiveness. I'm especially thankful to the numerous experts, delegates, and observers from various member states, the Permanent Bureau for their selfless participation, leadership, and amazing support, and of course, our office exceptional services in the past few years. I would also particularly mention about my predecessor, the three former representatives, Justice Hartmann, Professor Anselmo Reyes, who was able to join us today, and Solicitor General Frank Poon. They have been able to get to where we are today based on the accumulation of achievements. Together, we will continue to confront various challenges such as a post-pandemic and change in the international situation, and to contribute to the growth of Hcch and its conventions. And furthermore, we will look into the process of harmonization and unification of private international law in the global area. And of course, we also look at the situation in our region. Obviously, and most crucially, I would like to thank the central government of the People's Republic of China and its diplomatic officials, as well as the government of the Hong Kong SAR for the continuous support to the office. Thank you to the government officials, academic experts, and legal practitioners who engage in various activities. I'm as certain as ever that the Hcch and its regional office will continue to rely on your support in the future. Thank you very much. We have journeyed together for the past decades. Let's look forward to more activities and good outcomes of future decades. Thank you very much.
Thank you, Professor Zhao. 10 years of hard work has yielded fruitful results. We are so grateful for every member's unremitting efforts for ROAP. Next, we have prepared an introduction video of Hcch. Please enjoy it. And now I pass the floor to MC.
A mother has taken her child abroad against the father's will.
Two business partners based in different states want to choose a commercial court to hear any dispute arising out of their contract.
A plaintiff needs to serve process on a defendant abroad and then take evidence in that other state.
A student needs to show her birth certificate and diplomas abroad. An investor to show an extract of a commercial register.
A child is adopted internationally.
A divorced mother wants to claim child support from her former husband who has moved abroad.
To secure a bank loan, a company proposes collateral in the form of securities issued in various jurisdictions.
In today's world, such cross-border situations involving individuals or businesses are commonplace. To handle them effectively, private international law or conflict of laws rules are applied.
These rules are like road signs, pointing the way to resolving tricky questions. Which court has jurisdiction? Which law applies? Can a foreign judgment be recognized and enforced? how does legal cooperation between states work? But legal certainty and predictability require states to apply the same private international law rules, to follow the same road signs.
Unifying such private international law rules is the mandate of the Hague Conference on Private International Law, or HCCH. The HCCH is an intergovernmental organization. Dating back to 1893, it is the oldest of the many legal organizations and institutions based in The Hague. The acronym HCCH is derived from the English and French names of the organization. In addition to its headquarters in The Hague, the organization has regional offices in Buenos Aires and Hong Kong.
The HCCH unifies private international law by negotiating international treaties, the Hague Conventions, which states may then join. These conventions build bridges between different jurisdictions. They don't change the domestic laws in each jurisdiction, but simply connect them. The HCCH operates only in civil and commercial law, not criminal law. It isn't a court or tribunal. It renders no judgments. It devises sensible, practical rules for international civil and commercial matters across its three main fields of work: international family and child protection law, international civil procedure and litigation, and international commercial and financial law.
Any state may join a Hague Convention, even if that state is not a member of the HCCH. However, only members of the organization negotiate new conventions. Members also have priority access to technical assistance. Today, more than 150 states are connected to the work of the HCCH. This shows just how broad and practical the work of the HCCH is.
In our fast-paced and ever-changing world, the Hague Conventions help individuals, families, and companies make informed decisions and find practical, sensible solutions to their cross-border problems, despite international borders and differences in legal systems. The HCCH, connecting, protecting, cooperating, since 1893.
Thank you, ladies and gentlemen. So after the opening section, we will now move on to the panel discussions of today. Today's workshop composes of two panel discussions, and for the first panel section, it's cooperation as a means to support transnational litigation. And we are pleased to have Mr. Adrian Lai, JP, as our moderator. Ladies and gentlemen, a big round of applause to welcome Mr. Lai onto the stage. And joining us for this panel section, we have three speakers. They are Mr. Ru Villanueva and Professor Yoko Nishitani. They will be joining us online. Definitely, we also have Dr. James Ding, who will be joining us physically here at Hong Kong. Big round of applause to welcome them onto the stage. So without further ado, I can see our speakers and moderator are ready. I would like to pass the time to our moderator, Mr. Adrian Lai, please.
Good morning, good afternoon, good evening, depending where you are. My name is Adrian Lai, Deputy Secretary General of Asian Academy of International Law. Yesterday, the Secretary of Justice referred the Hague Conference, UNIDROIT and UNCITRAL, to three sisters of private international law. Today is a turn for the eldest one, at least in terms of age, to showcase its contribution to this international community, how the cross-border litigation works with the facilitation of three conventions. The panel is going to cover three very important conventions: the Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, the Convention on Taking of Evidence Abroad in Civil and Commercial Matters, and the Convention abolishing the requirements of legalization for foreign public documents. Those conventions, the name in their long form, sounds less familiar to you. But if I refer them to the Service Convention, the Evidence Convention, the Apostolate Convention, that will immediately sound very familiar to you, at least if you're practicing in the legal society and in particular litigation lawyers. Those three conventions have silently made significant contributions, bridging the gaps, facilitating cross-border litigation. Today, we have three very distinguished speakers covering these three conventions. First, we have Mr. Raul Bautista Villanueva. Mr. Villanueva is a court administrator of the Supreme Court of the Philippines. He joined the judiciary in December 2002 when he was appointed as the presiding judge of Branch 255 of Regional Trial Court. And in March 2009, he became the executive judge of the Regional Trial Court. He was also actively involved in the Philippines Judges Association and was its executive vice president. He was made the deputy court administrator in 2010, and from March 2022, he was appointed as the head of the entire office of the court administrator. In addition to his enviable career in the judiciary, he is also a professorial lecturer of the Philippines Judicial Academy. Mr. Villanueva is going to cover the Service Convention. The next speaker is Professor Yoko Nishitani. Professor Nishitani is a professor of private international law at Kyoto University. After graduation in Japan, she received a doctoral degree from the University of Heidelberg. She continued her research in many jurisdictions, both civil law and common law, such as in Milan, Florence, New York, Paris, and Hamburg, etc. And she is also a visiting professor in many jurisdictions as well, both common law world and also the civil law world. She had also had the privilege of being the Director of Studies and the lecturer of the Hague Academy of International Law, which is truly a remarkable achievement for all practitioners in the field of international law. And she's also a member of the curatorium of the Hague Academy. Professor is going to cover the Evidence Convention. And we have the last but not least speaker, Dr. James Ding, who is sitting next to me. Dr. Ding was educated in Hong Kong. He obtained his master's and doctoral degrees in Japan and Australia, respectively. He's a barrister and joined the DOJ in 1999. He's currently the law officer of the International Division of the DOJ and reports to the Secretary for Justice on matters concerning international law and international legal cooperation. He was seconded to the Permanent Bureau of the Hague Conference and participated in negotiation with the international counterpart as a member of the Chinese delegation. Dr. Ding is also currently the chair of the APEC Economic Committee. So without further ado, may I invite the first speaker, Mr. Villanueva, to cover the topic on Service Convention. Mr. Villanueva, I'm afraid you have muted yourself.
Pardon me for that. Can you hear me now, Adrian?
Yes, thank you.
Thank you so much for that generous introduction. Of course, before I proceed, my greetings to all of the participants of this workshop to celebrate the 10th anniversary of the Regional Office for Asia and the Pacific of the Hague Convention, Hcc, I mean. Thank you for inviting me to speak before all of you. My greetings as well, of course, to our dignitaries who spoke earlier, His Excellency Liu Guangyun, His Excellency Paul Lam Ting Kwok, and of course, the Secretary General Christophe Bernasconi, whom I had the pleasure of meeting personally when he visited Manila a few weeks ago. And of course, our Supreme Court when he met our Chief Justice Alexander Esmundo. Likewise, my greetings to my fellow speakers who will present their and come up with a presentation later, Professor Yuko and Dr. James. Anyway, I know that I have a few minutes to make my presentation, so allow me to proceed already. So let me just give you some brief facts about the Hague Service Convention. The Hague Service Convention, or formerly known as the Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, actually was concluded on November 15, 1965. It consists of 31 articles and 3 chapters on judicial documents, extrajudicial documents and general clauses. Likewise, this convention was done in both English and in French, which are both equally authentic versions of this convention. And there are 79 states out of, I think, 19, more than 90 members of the HCC. 79 states are currently contracting parties to this particular convention. And when it comes to the Philippines, this was ratified by our country only on March 3, 2020, before the onslaught of the pandemic. And this entered into force on October 1, 2020. I'm sorry if the presentation appears to be a little disorderly. This is not the version that I sent, but unfortunately, I don't think the applications match. That's why it appears this way already. So my apologies for that. Anyway, moving on. Let me see. Trying to. I can't seem to control the. Adrian, can you hear me?
Yes, we can hear you very well.
I can't seem to control this PowerPoint. I was able to do so earlier, so I'm wondering why it's not working now. Because I want to go to my next slide.
I believe those the technicians will be able to assist, but
Yes, please. Because I'm now moving to the salient features of the convention itself. Now I'll wait.
yes, we see the next slide already.
You can see the next slide.
Yes, starting from
the
the Hague Convention on the Service of Broad of Judicial and Extrajudicial.
Yeah, but I'm going to the next slide. Sorry, Adrian. I can't seem to control it. I'm not able to control. Perhaps the technical people can help in this regard.
Can I please check with the technical people whether you have the control over the slides?
Yes, I was able to control with respect to the first 3 slides, but now I can't move it on the next slide.
Yes, I've been instructed, Mr. Venezuela, let's redo the control on our side.
Oh, yes, please. Please.
You let me know if you want to turn the page, then we will turn the page for you.
Yes, please, can you move to the next slide now, please?
Thank you.
Yes, thank you. Thank you, Adrian. Thank you for your assistance.
So we should go to the 3rd slide.
4th slide already,
Okay,
please.
3rd slide, please.
4th. Next slide, please.
Yes, we see a table.
Can't seem to.
It's page 5 on the bottom right-hand corner.
Yeah.
We see page 5.
Yeah, but unfortunately, it's not moving in my screen so that I can see it. It's not moving in my screen, so I won't be able to at least do the presentation. Adrian?
Yes.
I'm sorry for this one. I can't seem to move it. I'm wondering why.
Let me check with those technical people.
Yeah, yes, please. Let me just mute myself in the meantime.
Why don't we do this? Mr. Bolanueva? Mr. Bolanueva, why don't we do this? We try to resolve the technical issue. Can I just pass the floor to Dr. Ding, let him speak first, and then we gain some time to do the to solve the technical problem. Would that be okay?
Go ahead. It's fine by me. Yeah, fine by
I'm sorry
me.
about that. Yes.
Yeah, I'm sorry as well.
No worry. So can I invite?
Let me just leave.
Yes.
In that case, let me leave in the meantime the meeting so that I can fix it. Also address my technical issue.
Thank you. Can those technical people keep connecting with with Mr. Venezuela and to resolve the technical issues while we are hearing from Dr. Ding? Thank you. Dr. Ding, sorry about that. Can I invite you to speak on the Apostolic Convention?
Thank you, Adrian. Thank you for the Hague Conference for inviting me to speak on the Apostille Conventions. I will briefly introduce the Apostille Conventions, some of the developments, and also speaking from the experience of Hong Kong SAL. I hope I will be able to control that slide here. So I will basically cover just a few aspects of the conventions, and then I will talk about the benefits of the conventions from Hong Kong experience. Conventions is a very old conventions, 1961 conventions, but it's the most popular and widely ratified Hague Conventions. There are currently over 120 contracting states to the conventions. Both are members of the Hague Conference and also non-members of the Hague Conference are also parties to these conventions. And the convention is applicable to Hong Kong SAR. It has been applying to Hong Kong before unification, so it has applied to Hong Kong for many years. And it's also one of the most widely and frequently applied Hague Conventions. Hundreds of competent authorities have been designated under the conventions, and millions of apostilles are issued every year. The purpose of the convention is very simple. It aims to abolish the requirements of legalization and facilitate the use of public documents abroad. I'm not sure if you are aware of the process of legalization. Sometimes we call it consularizations. You have to go through the embassy or consulate, and the Ministry of Foreign Affairs. Is a very cumbersome process, and it takes time and money. And for some countries, a very costly process as well. So the Apostille Convention seeks to abolish these cumbersome requirements. It saves costs and money. And why we need this kind of legalizations? Basically, when we do cross-border transactions or cross-border movement of people, there are some documents that will need to be authenticated. And in the absence of the Apostille Conventions, very often one will have to go through the process of consolidations or legalizations in order to authenticate those documents. Therefore, the Apostille Conventions aims to resolve these issues by providing a very simple one-stop service to facilitate the circulation of public documents. That brings me to the next point. The scope of the convention is limited to public documents. For example, birth, death, marriage certificates, notarial certificates, or some business registration certificates, etc. The public nature of the document is determined by the state of origin, which issued the apostilles. It does not apply to private documents. So if it's a private contract between two parties, it is not covered by these conventions unless the contract is notarized. Then the notarial certificate could be apostilled. The apostille may also be issued in respect of documents from supranational and intergovernmental organizations in the state of origins. That's a bit more complicated. There's another working group that has been constituted to discuss these issues. I was the chair of that working group, and we came up with some recommendation on how to do that. I'm not going to cover that here. But for countries that have some international organization headquarters in their countries, this will be a very useful means to facilitate the authentication of the documents issued by these organizations. Where does the convention apply? It applies to over 120 contracting states around the world, and it applies to public documents which have been executed in the territory of one contracting state and which have to be produced in the territory of another contracting state. So it has to be international, so that productions, issuance in one contracting state for the use in another contracting state. When does it apply? Once the convention has entered into force for a state, an apostille may be issued for public documents executed before entry into force for the state of origin. An apostille issued before the entry into force of the conventions for the state of destinations must also be accepted. And legalizations done before entry into force of the convention may still be given effect. It doesn't affect the validity of those legalized documents before entry into force of the conventions. So you can see it covers very broad range of temporal elements of these documents issues. The process of issuing apostille is quite simple. A contracting state may designate one or more competent authorities to issue apostilles. In federal states, for example, we can see many different competent authorities located in different territorial units. But for some states, there are only one single competent authorities. It's up to the contracting state to designate their competent authorities. And only competent authorities designated by the contracting state may issue apostilles. And as I said, whether it's centralized or decentralized model is up to the states to decide. And if you go up to the webpage of the Hague Conference, you can find a list of these different competent authorities. In the state of origins, that means the state issuing the documents, what are the obligations? The state of origins will have to accept proper requests by an applicant if they want to apply for the apostille service. And there's also an obligation to verify the authenticity of the signature on the underlying documents and the capacity in which the person signing the documents has acted, and the identity or the seal or stamps which the documents bear. Then the competent authorities will have to issue an apostille using the model certificate, which is annexed to the apostille conventions. And it's also recommended that they use the multilingual test and also the additional test in the paper or e-apostille. I will go to the e-apostille later. And it's also a duty to keep a register and to verify the issuance upon request. I will also mention the e-register later in my presentations. So that's the obligation for the state of origin. And for the state of destinations, the main obligation is acceptance of the apostille. The convention exempts the legalization requirements. Therefore, the state of destinations as a contracting parties to the apostille convention must accept the apostille in lieu of the legalizations. Unless there are some exceptions. For example, if the apostille document falls outside the scope of the conventions, for example, it's not a public document or is not issued by a competent authority of a contracting state, then it's not covered, obviously. And also, there's certain information that must be provided in the model apostille. We call it the 10 standard informations. And also, there's some other exception if there's forgery or detached apostille, things like that. And what will be the effect? The apostille certifies only the origin of a public document, not its content. Actually, and there's no obligation to verify the content of the underlying document. And the apostille is effective in all contracting states. Acceptance of the apostille does not affect the acceptance, admissibility, or probability value of the underlying document. It only authenticates the person signing the documents or the origin of the document. It does not go into the contents of the underlying documents. That it is a concept that some people may get confused. They thought that if you issue an apostille, whatever the document said is true. It is not necessarily the case. It only authenticates the origin of the document. And therefore, the apostille does not preclude rejection of the underlying documents due to the domestic law. For example, if the domestic law requires certain formalities or translation requirements or some requirements about the signatures, the apostille conventions does not do away all these domestic law requirements. Now, I'd like to mention very briefly about the EAPP, Electronic Apostille Program. It refers to the development and implementation of a low-cost, operational, and secure software model for issuance and use of electronic apostille, and operation of an electronic register of apostilles by relying on existing and widely used technologies. To date, I think about 50 contracting states have implemented one or both components of the EAPP, either an e-apostille or an e-register. Since 2005, the Hague Conference has organized regularly jointly with authorities in different contracting states and international forum to discuss and exchange views on the developments of EAPP. And in 2014, the 9th International Forum on EAPP was held in Hong Kong. You can see a photo here. So that people gathered together to discuss the developments of the EAPP and how we can do better, and also exchange different practices. And for the EAPP components, as I said, that basically two components. One is about e-apostilles and the other is e-registers. For the e-apostille, basically it means issuance of apostille in electronic format with a digital certificate. For e-register, it refers to operation of a apostille register in electronic format that can be accessed online to verify the origin of the paper or e-apostilles. As I just mentioned, there's obligations to provide a register for the apostilles, so the e-registers helps with this requirement. Nowadays, you can imagine in our digital economies, there are many and more things that are being electronicized or digitalized, so that we have more documents which are in electronic format. Therefore, the EAPP is very timely and very useful for economies and jurisdictions to adopt. I will now go to talk very briefly about the experience of Hong Kong. In Hong Kong, we issue apostilles in bilingual versions, both English and Chinese, and the competent authority is issuing the apostille is the High Court. And we have adopted the EAPP components on e-registers since 2014. And that means all the apostilles are stored in the electronic register, and also people can access the e-register to verify. In the past, when we do not have the e-register, it's very rare that we receive requests for verifications. But now with the e-register, we receive more and more requests for verifications that helps the operation of the conventions. For example, in 2020, we have 812 requests, and 2021, we have almost double the number. And this year, we also have a very high number of requests coming in. These statistics show that both the popularity and effectiveness of the e-register in this digital age. And we also participate very actively in international meetings on the apostille conventions. For example, I was the chair of the Special Commission in 2016, and also the working group in 2017 on the apostille conventions, and my colleagues also participate in a different forum and on the EAPP forum as well. So lastly, I will just basically sum up some of the key benefits of the conventions. First, it provides a one-step process that reduces the time and cost for authenticating the documents. The abolitions of the legalizations can free up consular resources and other public resources previously required for provision of the legalization service. I talked with some people in the consulates or embassy. They were happy with the application of the apostille conventions, because instead of doing the consulations work, they can spare their time to do something more, I wouldn't say meaningful, but more other areas of work that they prefer to do, rather than just checking the signature and things like that as the process of legalizations. So that can help to free up the resources for the consular or the embassy services. And apostille is very widely recognized. As I said, it's one of the most popular ratified Hague Conventions. And it also has the benefit of trade and investment facilitations, because it facilitates the use of circulation of public documents most often you will require those documents when you trade across borders or invest in other countries. And the benefits to the government, as I said, it free up the council resources, it facilitate circulation of its documents in overseas. So the documents issued in one jurisdictions can be circulated very easily in other jurisdictions. Of course, it brings benefit to the committee by saving the time and cost for the people who are using the apostilles. And the trade and investment facilitations can also attract foreign investment and enhance mobility to people. That's why we can see that there's some statement issued by the ICC, World Bank, and APEC supporting the use of the apostilles. And therefore, it's a very meaningful and useful conventions. So for those countries that have not yet been a party to the apostille convention, I would strongly encourage you to take look at this convention, and you will find a lot of benefits of this convention. Especially for the Asia Pacific, the mobility of people in this area often require the use of authenticated documents, and the apostilles can save the time and cost for the people and also for the government. If you want to know more about the apostille convention, I will encourage you to go up to the websites of the Hague Conference. You can find more information in the publications that's shown on the slide. That concludes my presentations. Thank you very much.
Thank you, James. Thank you very much. A declaration of interest. I'm a user of this convention. When I got my marriage certificate to get the certificate from the High Court when it used to be used for a foreign consulate. But enough about my personal life. Wearing the hat as a barrister, when we want to fight a case, when we want to sue a person who is residing outside Hong Kong, we need court's permission to serve the document outside territory. But after that, it's not the end of the matter. We need to find ways to serve the documents properly. And Ra, can I have your back? Mr. Villanueva is going to explain to you how the Service Convention facilitates service of legal court documents abroad. Ra, you have muted yourself. Please unmute yourself.
Yes, thank you again, Adrian. I thank as well everyone for their patience as I proceed now with my presentation. Next slide, please. Next slide, please. Because I've already started with my, at least a little background on the Service Convention, or what I mentioned earlier is formerly known as the Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters. Next slide, please. Next slide, please. Regarding the salient features of the Hague Service Convention, first is it's applicable only with respect to judicial or extrajudicial documents for service abroad involving civil or commercial matters. Likewise, there is a need for a central authority to be designated for purposes of receiving documents, whether extrajudicial or judicial documents for purposes of service, either coming from a requesting party sent to a requested party, or coming from the central authority of a requesting party or state with respect to those that will be sent to another state, through the central authority as provided herein. Likewise, take note that there are model forms for purposes of complying with the Hague Service Convention with respect to the request that will be made to serve judicial or extrajudicial documents. And likewise, there is a model form with respect to the certification or certificate or return, as we call it here in the Philippines, when there is proof already of either service to the recipient, or if there is difficulty regarding the same, then a report or a certificate will have to be issued to that effect. Likewise, the Hague Service Convention then recognized that other forms of service can still be done, either through the diplomatic or consular offices, or even through the postal services, or even through direct communication among the parties. Take note that there is also a required payment to reimburse expenses that may be incurred in connection with the service not done for those judicial or extrajudicial documents covered by the Hague Service Convention. And also, there are specific grounds for the refusal to serve such documents by the requested state, and one of those is, of course, when it will infringe on the sovereignty or security of the requested state. Next slide, please. Likewise, with respect to the service of extrajudicial documents, take note, the same process will be done as with respect to judicial documents. And finally, one thing that I would like to share with all of you is that in the Hague Service Convention, it is stated therein that other authorities, other than a central authority, other authorities by the contracting party, the state, the requested state, can also be designated. Next slide, please. This part of my presentation is now to inform you how we in the Philippines implemented the Hague Service Convention. So take note that the convention was ratified or acceded to by the Philippines on March 1, 2020. So even before, next slide please, even before, take note, even before we acceded to it, the Supreme Court of the Philippines already named a central authority for purposes of the Hague Service Convention, and that is the Office of the Court Administrator. That is the office that I head right now. So that means that it is my office that serves as the central authority when it comes to judicial documents that come from requesting states. So any judicial document that you would want to serve to a recipient who is a resident, for example, or an addressee who is residing in the Philippines, anywhere in the Philippines, you have to course it through my office, the Office of the Court Administrator here in the Philippines. So take note, even before we acceded to it, the Office of the Court Administrator was already named as central authority. And the Supreme Court of the Philippines, prior to the coming into effect or force of the Hague Service Convention in the country on March 1, 2020, already came out with guidelines to implement the Hague Service Convention on September 11, 2020. So we were ahead, again, prior to the Hague Service Convention coming into force in the country. The Supreme Court already issued the guidelines for the implementation thereof. Next slide, please. So what are the salient features of our Administrative Order number 251-2020? This is the issuance coming from the Supreme Court of the Philippines to implement the Hague Service Convention. Next slide, please. You will notice that many of our guidelines are actually taken from the Hague Service Convention. So for example, we have to be clear about what are the judicial documents that are covered by this Hague Service Convention. So we are referring only to judicial documents that involve commercial or civil matters. Likewise, with respect to the Hague Service Convention, we made it clear that it will apply insofar as our implementation of this said convention is concerned. If, of course, it will come from a state party, meaning it should come from any of the contracting parties, 79 or 78 parties who already acceded to the Hague Service Convention. It will not apply to those who are non-state parties. Second, the address should be clear so that it will enable us to serve it. Likewise, it should be a judicial document that will be served. Why am I emphasizing this? Because when it comes to extrajudicial documents, these are documents regarding, for example, demand for money, for example, or a letter of demand, for example. This is something that will not be coursed through the Office of the Court Administrator. Extrajudicial documents in our country will have to be coursed through our Integrated Bar of the Philippines. That's the association of all lawyers here in the country. There's an association. It's supposed to be a course through them. So they will have their own guidelines regarding the matter. Next, of course, is with respect to the grounds for objecting the service by my office, the Office of the Court Administrator. We followed what is provided in the Hague Service Convention. If it will, one way or the other, infringe our sovereignty or affect our sovereignty or our security, then that is something that we can refuse not to serve. Likewise, of course, the objectives of the Hague Service Convention, we have incorporated that in our guidelines. Next slide, please. So there are two kinds of well, before the two kinds of modes that we follow regarding this convention, the definition of terms we also adopted. We came up with this definition of terms to be clear regarding what can be served by the central authority, which is the Office of the Court Administrator, and that is judicial, and that is with respect only to judicial documents. Likewise, we identified who is a forwarding authority. In our country, it's all the courts. Our judges, and justices can be the forwarding authority, meaning they can forward judicial documents to other state parties through their central authorities. So they don't have to pass through my office. And then likewise, who are the competent authority to make a return or to serve these judicial documents coming from other countries? It is of course, our judges as well, our trial courts. So, and take note, we have defined extrajudicial document as private documents or public documents not directly connected with any pending matter before foreign courts. Next slide, please. So, there are two kinds of requests that can be coursed through our that can be the subject of the Hague Service Convention in the country. First is a request coming from the Philippines, from our end, to other countries. So as I mentioned, these kinds of requests need not pass through our central authority, the Office of the Court Administrator. Our courts, once they issue an order, there is a need to serve some judicial documents to other countries with respect to a case pending before them, then they can do so already directly through the central authority of the requested state. Next slide, please. With respect to a request for extraterritorial service of judicial documents in the Philippines, so coming from abroad, coming from state parties who would like us to serve judicial documents, then those are the documents that will pass through my office. So take note, when this happens, there is a cost that that will be required to be deposited, and that is $100 to reimburse the expenses for serving these documents. And what we do once we receive these documents, our office, we have what we refer to as a service convention unit in my office, and that office determines if it is compliant with the forms as provided in our guidelines. Once this is compliant, then we immediately send it to our courts, and the courts will now serve it. And then they will give the certificate directly to the requesting party or state. Next slide, please. So let me now just give you an idea of our experience here in the Philippines so far since October 2020, when we already implemented the Hague Service Convention. Next slide, please. So based on our statistics, you can see here that since October 2020 up to October 31, 2022, a few weeks ago, we have a total of 884 requests that were received coming from different parties or states. And out of these requests, we were able to process or serve 659, or with, of course, a success rate, so to speak, of about 74.5%. Why were we not able to serve the other judicial documents coursed through our central authority? It's because either there was no deposit of the $100 required, or the address given was not sufficient for us to be able to serve these documents. Next slide, please. And just perhaps to let you know that based on our statistics, the country that made the most number of requests insofar as serving judicial documents through our central authorities concerned is the United States, then followed by Canada, and then France, Germany, Japan, South Korea, Italy, Norway, Netherlands, and China. So China, of course, South Korea, Japan, and they belong to this particular regional office. Next slide, please. Just to share some challenges with all of you with respect to our implementation of the Hague Service Convention. Next slide, please. So again, like I mentioned, one of the things that we encountered is, among others, there are so many documents sometimes that are being coursed through us to be served and there's a need to evaluate all of these things, look into this, they comply with the form. Likewise, if there is insufficient details regarding the address of the recipient, that's something that would prevent us from serving these judicial documents. And also the deposit. Sometimes the deposits are not enough, and there's no means for us to be able to collect the deficiencies because the details coming from the requesting party is not sufficient as well. But at any rate, we're happy to note that this development insofar as coursing extraterritorial service of judicial documents through the Hague Service Convention has provided us the mechanism to speed up, expedite these kinds of service to insofar as judicial documents are concerned. So with that, I would like to thank all of you for your kind attention. My apologies earlier for the technical difficulties that we encountered. So I, of course, bid you a most fruitful workshop. God bless you all. Thank you very much.
Thank you, Rolf, for your very comprehensive introduction of the service convention. And in fact, 75% success rate of service is really a remarkable result, I must say.
Thank you.
And also thank you for sharing the difficulties that your office have encountered in passing the documents to the addressee. And in fact, this convention is very important because from time to time we receive instructions to advise how the document to be served outside Hong Kong. And always look up the website of the Hague Conference and then write my advice and bill my fees. So perhaps Mr. Bernasconi and Professor Zhao, you should consider setting up a help desk in Hong Kong, advising the instructing solicitors, so that you can charge that portion of fees. So after the documents have been served on the defendant residing overseas, so you have commenced the proceedings. Now the second very important part is evidence. When evidence is located outside Hong Kong or outside in a foreign jurisdiction, how can you get hold of such evidence? Today we have Professor Nishitani to explain to you the evidence convention. Professor.
Thank you very much, Mr. Lai, for your kind, generous introduction. Ladies and gentlemen, it's a great pleasure for me to give a talk in this conference, and I'm truly grateful and honored to be here. The topic I'm addressing is the Hague Evidence Convention. Okay, I'm sorry. So the Hague Evidence Convention has attracted already 64 contracting parties. And in the Asia-Pacific region, we have these series of countries. However, my own country, Japan, has not yet joined the Evidence Convention, only the 1954 Civil Procedure Conventions, and other countries either. So collecting evidence, however, is crucial in international litigation, and that shows a case from 1986 decided by the Tokyo District Court in Japan. In this case, there was an airplane crash occurred in Taiwan, and the cause of the accident was not known. All the passengers and pilots passed away, unfortunately, and the remaining family members started court proceedings against Boeing and also United Airlines, who had sold the airplane to Far Eastern Air Transport. So the airplane itself was operated by Far Eastern Air Transport. And although there were many remaining family members in Japan, and the Japanese court said there was international jurisdiction in Japan, they carefully started to check whether they can proceed with this case before the Japanese court. And ultimately, they found out that the cause of the accident was not known, and all the witnesses and all the written evidences were concentrated in Taiwan. However, because there is no diplomatic relationship between Japan and Taiwan, there was no way of obtaining evidence in such a case through a diplomatic channel. And this is why, ultimately, the Tokyo District Court said, unfortunately, we cannot hear this case. We dismiss this case. Please go to the Taiwanese court which is a more appropriate forum, and we don't hear this case. So as this case shows, when the evidence is concentrated in a foreign country and we do not have any access to that evidence, it's sometimes impossible to proceed with the case before the Japanese courts. And this is why I think the Hague Evidence Convention provides a very important means to help bridge between contracting states to obtain evidence located in a foreign country. When it comes to the structure of the Evidence Convention, I'm sorry, it's a little bit twisted, but I hope you can see on the slides. So there are so far 4 major Hague Conventions on judicial assistance, and the Evidence Convention is the last one from 1970. When court proceedings are pending in state A, but evidence is located in state B, then court or the attorney or the parties would want to have access to the evidence located in state B. And then Hague Evidence Convention primarily establishes the system of central authorities, and through the cooperation between central authorities, collecting evidence from state B becomes possible. When it comes to the first avenue of using the central authority, it is mandatory to go through the central authority between the countries, and it establishes administrative cooperation between the contracting parties. This is regulated in Chapter 1 of the Evidence Convention. What is interesting, however, is that Chapter 2 of the Evidence Convention opens another avenue of obtaining evidence located in a foreign country. Namely, the convention allows also to use consular officials sent by the state A, where the court proceedings are pending, and the consular officials sent to state B may, under certain circumstances, may become active and collect evidence there. It is also provided for that state A can appoint a commissioner so that the commissioner can collect evidence in state B. This can be an independent attorney, for example, admitted in bar in state B, or any other kind of expert under certain conditions as well. So by having these 2 avenues, the Evidence Convention has flexible mechanism, which plays an important role when discuss the possibility of using video link, as I will show later. When it comes to the European Union, they have evidence regulation, and there they have another mechanism of cooperation between courts. And central authority of the administration only plays a role of assisting courts in that respect. And some authors say that this model can be also taken over by the Hague Evidence Convention to improve the system. That may be a possibility for future improvement, but as we will see, the current Evidence Convention itself already contains flexibility to allow various avenues of collecting evidence. When it comes to challenges of the operation of the Evidence Convention, we have to bear in mind that collecting evidence is understood very differently between civil law systems and common law systems. For civil law countries like Japan, collecting evidence is a kind of judicial act which needs to be exercised by the state. Whereas in common law jurisdictions, it is considered as a private matter and primary responsibility of parties' counsel. So this is why there have been a lot of discussions how to deal with US pre-trial discoveries. So in civil law countries, in order to collect evidence in documents, it is necessary to precisely identify which kind of evidence is needed and requested to the state of execution. However, the US pretrial discovery is known to be to allow very extensive discovery in defendants' documents. So in certain cases, as we hear, it's possible for the counsel of the plaintiff to go to the defendant's office and collect any kind of documents that seem to be relevant for the case. So this kind of pretrial discovery order coming from the US is a difficult issue for many countries. And this is why the Evidence Convention has a provision in Article 23, which allows contracting states to make a reservation and say, we do not allow pretrial discoveries to be made to our states from the United States. And there are 44 states out of 64 member states that made this reservation, and that includes even the United Kingdom and Australia as common law jurisdictions. So this reservation is largely used to block the use of pretrial discovery. We should, however, note that the US itself has been also amending the pretrial discovery orders, and they started to limit and clarify the scope of discovery so that at least any privileged matters that are relevant to the subject matter can fall within the discovery order. So it's not that you can take any kind of documents, but it must be related to the subject matter of the case. Because Japan is not a member state of the Evidence Convention, we use with the United States our US-Japanese consulate agreement. And under this consulate agreement, it is allowed that US attorneys make a deposition in the US Embassy or consulate in Japan, so that they invite possible witnesses located in Japan to come to the US Embassy or consulate, and the counsel can make a deposition there. And this is allowed as a judicial assistance system officially by the Japanese authority. The question is, however, what will happen when the counsel directly comes to Japan, stays in a hotel, and makes a phone call to a possible witness and invites to give a voluntary deposition? Whether we may allow this kind of deposition or not, it's still controversial among Japanese academics, because we consider it again as a sovereignty issue. If a foreign authority comes to Japan and collect evidence for the use of foreign court proceedings. The challenges of the Evidence Convention is again related to the US pretrial discovery orders, because the US Supreme Court precedent in aerospatial decision from 1987 explicitly said that the application of the Hague Evidence Convention is not exclusive. So it is possible for the parties to use, to ask to the courts to render a pretrial discovery order by circumventing the Hague Evidence Convention. And the reasoning was that the judicial assistance system under the Evidence Convention is not certain and can include delay and is costly and so on. And this is why the Supreme Court said it is allowed to the parties to go the way of using pretrial discovery orders under domestic rules. In order to counter these kind of extensive pretrial discovery orders, actually, a series of states have started to adopt so-called blocking statutes. These blocking statutes, for example, adopted in France, prohibits compliance with the US discovery orders. So when a party decides to comply with the US discovery order, then the party will incur penal sanction. And this has had a certain impact on the case. However, the US recent court decisions have started to accept that French party is subject to this strict blocking statutes. This is why US courts accepted in certain cases that Hague Convention actually be used instead of domestic pretrial discovery orders, so that the proceedings can move forward by allowing the parties to appoint a commissioner who collects evidence, like a French independent attorney there. In terms of digitalization, and the use of video link has been discussed by the Hague Conference in recent years, and under the Chapter 1, letters of request can be sent between the contracting states by using the central authority mechanism. This can include the use of video link to allow the presence of parties or representatives sitting in State A where court proceedings are pending, and connect with the witnesses located in State B, so that video link allows direct communication in court proceedings. Also, Chapter 2, counsel or commissioner can be used under the convention, and then this again makes it possible to use video link of witnesses on experts located in the state of execution. The remaining challenges is that sovereignty issues still remain for civil law countries. So, for example, Korea started to allow video link for cross-border cases, but it only allows the transmission of the court proceedings via video link, and the parties sitting in a foreign country in the court proceedings cannot directly take part. And Japan entirely exclude the use of video link from the Japanese courts, so it's still a hurdle to overcome to be able to use video link in the future. And the need for coordination between contracting states shall also be considered, and direct communication by emails or phone calls would be desirable in the future to make the system efficient. So as I hopefully could give an overview of the Evidence Convention. It is an important mechanism to allow collecting evidence in a foreign country, and make the administration of justice in the state where the court proceedings are pending to move forward. The current Evidence Convention already includes flexible rules, not only in Chapter 1, but also in Chapter 2, by using the consular officials or appointing commissioners. And this will allow leeway to further developments, I think. And also the use of video link is possible within this framework. And it's up to the practice how the convention will be implemented. And I hope that further cooperation will be enhanced, and further use of video link can become possible in the future. So thank you very much for your attention, and yeah, I look forward to further discussions with you. Thank you very much.
Thank you, Professor Nishitani. Spot on. We are supposed to end at 11. Now it's 11. I have to say that I've got 3 questions, but I think these questions have been answered in the course of the presentation. The first question is, if there's a conflict between evidence convention and domestic law, which shall prevail? So I gather from Professor Nishitani's presentations that there is certainly an area that needs to be resolved, because we see the tension between the US form of pre-discovery order and the blocking statutes on the other hand. So there's something that the Hague Convention may need to resolve. The second question is about whether Hong Kong used e-app. I think Dr. James Day in his presentation already explained that yes, we did. We do use e-app. The third question is not really for the speakers. The question is, are there any plans for China to join the Apostolic Convention in the near future? So I understand the convention has been extended to the two special administrative regions, but not mainland. Perhaps this is the job of the Professor Zhao to do your to persuade mainland Chinese government to adopt the convention. So thank you very much. Thank you all the speakers. Can I invite the audience to give a round of applause to our very distinguished speakers? Thank you.
Thank you. Thank you so much to our moderator, Mr. Lai, too. So I would like to invite Mr. Lai and also Dr. Deng, please remain seated. And we would like to take a photo with Mr. Villanueva and also Professor Nishitani. So we would like to have our two speakers online. Yes, on the screen now. So please look at official photographer right in front of you, Professor and also Mr. Villanueva. Just look into the camera. We can see your perfect face on the screen. Thank you so much for such a wonderful section indeed. Thank you, ladies and gentlemen. Another big round of applause to our moderator, Mr. Lai, and also our speakers, Mr. Villanueva, Professor Nishitani, and also Dr. Deng. Thank you so much. I think every one of you know what's coming next, as Mr. Adrian Lai said. This section ends at 11 and we're going to have a 15 minutes break. So ladies and gentlemen, we will now have a 15 minutes break. Remember to take all your personal belongings with you when you leave this hall, and the second panel section will resume in 15 minutes. So take your time and see you in a bit. Thank you. Ladies and gentlemen, our second panel section of today is going to commence soon, so please kindly make your way back to the hall as we would like to start a panel section on time. Thank you. 咁多位來賓，我哋今日接住落嚟咧，第二個專題討論環節啦，立即就會開始啦。所以喺呢個時候咧，我哋有請喺會場外面嘅嘉賓啊，麻煩大家都可以咧稍而喐步咧翻嚟我哋主會場嘅呢一個位置啦，等我哋可以準時啦開始我哋接住落嚟嘅環節嘅。唔該晒咁多位。Ladies and gentlemen, once again, gentle reminder, please make your way back to the hall so we can resume our section on time. Thank you. Ladies and gentlemen, good morning. Welcome back to the second section of our morning section of today. And upcoming, we will have the second panel section of today titled Legal Certainty and Predictability as a Means to Support Transnational Litigation. And we're delighted to have Mr. Clifford Tavares as our moderator. So ladies and gentlemen, let's put our hands to welcome Mr. Clifford Tavares onto the stage. As our moderator, Clifford Tavares will be joining us here physically at Hong Kong. We have three speakers joining us online. They are Professor Lee Kyu-Hu, Professor Afifa Kuzumadara, and also Professor Hcch. Ladies and gentlemen, also a big round of applause to welcome our three speakers joining us virtually online. A gentle reminder before I pass the stage and time to our moderator that we will have a Q&A section after this panel section. So our physical attendees, if you have any questions, do remember to scan the QR code located at the entrance where you can type questions to our Q&A systems. For our online participants, you can simply type your questions in the chat box. So without further ado, I think it's now time for me to pass over to Clifford Tavares. So Mr. Tavares, over to you, please.
Thank you, Vinci, for the kind introduction. Hello, everyone. Welcome everyone here physically and online to this second panel of the workshop. Good morning, professors. My name is Clifford Tavares. I'm a Principal Government Counsel with the Legal Enhancement and Development Office of the Department of Justice in the Hong Kong SAR. The 10th anniversary of Hague Conference on Private International Law Regional Office for Asia and the Pacific in Hong Kong marks the importance of the Hague Conventions, as the Secretary for Justice said in his welcome remarks this morning, in facilitating the full life cycle of transnational litigation. You've just heard from panel 1 just now, moderated by Mr. Adrian Lai, on how the Hague Conventions facilitate the service of process, the taking of evidence, and the authentication of public documents abroad. As Professor Zhao said yesterday, cooperation among states is one of the pillars of private international law. Now, this panel will discuss 3 other important projects of Hague Conference, which go to another pillar of private international law, giving legal certainty and predictability in support of transnational litigation. The Hague Convention of the 30th of June 2005 on choice of court agreements, the Choice of Court Convention, the Hague Convention of 2nd of July 2019 on the recognition and enforcement of foreign judgments in civil and commercial matters, the Judgments Convention, and of course, the ongoing work of the Working Group on matters related to jurisdiction in transnational civil or commercial litigation, the Jurisdiction Project. Background, the 3 conventions project stemmed from 1992, when the Hague Conference commenced work on the aspects of international jurisdiction of courts and the recognition and enforcement of foreign judgments in respect of the topic of private international law in cross-border litigation in civil and commercial matters. Originally intended to be one single convention, which brings together and harmonizes these rules, the Hcch scaled down to focus first on international cases involving choice of court agreements, which led to the conclusion of the Choice of Court Convention in 2005. In 2011, work was resumed on a more general instrument on recognition and enforcement of foreign judgments that would provide for a wider common denominator for potential contracting states, without prescribing any rules of court direct jurisdiction. This eventually culminated in the conclusion of the Judgments Convention in 2019. The focus since then turns to the ongoing work of the Jurisdiction Project, seen as the final puzzle of the Hague's work in this area, which deals with the question of reducing the risk of parallel litigation by aiming to specify the grounds which confers jurisdiction to a particular state. Today, we are very honored to have 3 distinguished speakers with us. I will introduce the speakers one by one as I go along. Each panelist will first make a short presentation. We will then have a panel discussion, and there will be a short discussion, Q&A session towards the end. Professors, our technical team can help control the PowerPoint slide in case that's necessary. So you can just say next slide, please, or of course, if you wish, you can control them yourself. So without further ado, may I introduce our first speaker, Professor Kuhu Lee, who will be speaking to us about the Choice of Court Convention. Professor Lee is a professor of law at Chung-An University School of Law in Seoul, Republic of Korea. He has served as a visiting researcher at Georgetown University of Law, a visiting scholar at Washington University School of Law. Among his various appointments, he is currently a vice president of Korea Private International Law Association and the editor-in-chief of Korean Yearbook of International Law. He is also the president of the Association of Content Property for the Next Generation and the Association of International Cultural Property Law. Professor Lee, the floor is yours. Thank you.
Thank you. So I'll be given the 10 minutes for my short presentations. The title of my presentation is Choice of Court Convention. the subtitle is the SWOT analysis. Next page, please. Next page. Next slide. Okay, good. No. Yeah. The number of the contracting parties to choice of court conventions is 37 so far. So it's a kind of the weakness of this convention right now. In Asia, I think that Singapore is the only one which ratified these conventions. Even though the Korean scholars are very friendly to the adoption of these conventions, we didn't ratify this or sign this convention. Next page. Okay, the weakness of the choice of court convention is that its scope. The definition of a consumer under consumer contract, the consumer under the Article 47 of the Korean Private International Law, it is classified as passive consumer, not including active consumer. It means it refers to consumer entering into a contract with another for the purpose of other than occupational or business activities. In the many users in the internet or in the metaverse are classified as consumers. It means this convention will not applicable to these types of consumer contract. That's the weakness. Next page. Also, it exclude in the validity or the infringement of the the industrial property rights other than the copyright and the related rights. So these days, and the infringement of the industrial property rights, also including the virtual design and on the in the metaverse, it does not include these types of the disputes. Next page. I want to just talk about the strength of this convention. The Korean case law used to be like this. It includes the requirements that the case has a reasonable connection with the Korean court. And next page. But in the Korean Private International Law, revised into 2022, it comprehensively revised and providing the detailed rules on the international jurisdictions, taking into account, this is the key point, choice of court convention, even though Korea did not sign the convention. Next page. So under the Article 8 of the Korean Private International Law, choice court agreement is presumed to be exclusive. Also, under this provision, the writing of the electronic means are allowed. So also, this is the key point. It does not require reasonable connection between the disputed case and the Korean court. So basically, the revised Korean Private International Law follow the step taken by the Choice Court Convention. That's the strength of this this convention. The next page. This is the full text of the Article 8 of the Korean Private International Law. I want to just skip this part because I don't have much time to do it. Next page. And so next page. Next page. This is also important. This is the opportunity of the choice court conventions. The law applicable to validity of the exclusive choice of court agreement, because we don't have any the choice court. We are not the signatory to the choice of court conventions. We need to provide the law applicable to validity of exclusive choice of court agreement. In the previous the case law, the Supreme Court just held that the law applicable to validity of exclusive choice of court agreement is a lex fori. However, the Article 8, Paragraph 1 of the Korean Private International Law, revised in 2022, said that the law applicable to validity of the exclusive choice of court agreement is the law of the country where the court chosen by the parties are located. So basically, what is the transitorial period? We just fully take consideration into the choice of court convention. Next page. So also the Korean Private International Law of the 2022, it includes the respondents provisions. Also, it was include the forum non-convenience provisions too. Next page. Next page. So also the opportunity of the choice of court convention is the concerns recognition and enforcement of the foreign judgment. Issues raised under the Article 217 and the 217 bis of the Korean Private, the Civil Procedure Act are, first is punitive damages, recognition of punitive damages and the recognition of excessive damages. Second is the exterior recognition of exterior application of injunctions issued by a court of a foreign country. Next page. So this is the provision of the Article 217 of the Korean Civil Procedure Act. Next page. Article 217 bis of the Korean Civil Procedure Act actually cut the the limit of the punitive damages. Next page. The Korean Supreme Court in the 2015 refused to recognize punitive damages. However, treble damages up to 3 times of the compensatory damages, it held that is not contrary to public morals of Korea because they increased the damages under specific laws, such as the called the economic laws and intellectual property laws, purpose to fully compensate the infringed damages. So I expected those treble damages up to 3 times of the compensatory damages under specific laws will be recognized in Korea. Next page. How about the extraterritorial application injunction issued by the court of a foreign court? Definitely, it is contrary to public morals of the Korea. The injunctions rendered by issued by the common law countries actually they raised a lot of the issues in international perspectives. In domestic viewpoint, definitely it is contrary to public morals of Korea. This is the all I have today. Thank you.
Thank you, Professor Lee, for the analysis on the Choice of Court Convention and in parallel sharing from the Korean law's perspective. Now, continuing with the chronology, let me now introduce Professor Afifa Kusumadera, who will be talking to us about the Judgments Convention. Professor, I appreciate I may rather call you Professor Afifa. So Professor Afifa is an associate professor at the Faculty of Law in Brawijaya University in Indonesia. She specializes in private international law and has been appointed since 2021 as one of the experts to assist the Indonesian Ministry of Law in developing Indonesian private international law. Professor Afifa has published her writings, including a book on Indonesian private international law. Her latest article on choice of court agreements in Indonesia will be published soon in a Journal of International Law in December this year. Professor Afifa, the floor is yours.
Thank you, Mr. Clifford Tavares. I hope my voice is clear enough for all of you.
It's loud and clear, thank you.
Okay, thank you. Good morning, ladies and gentlemen. Before I start my presentation, please allow me to thank Professor Yun Zhao and the Hcch Regional Office of Asia Pacific for inviting me to this workshop. With regard to today's event, I am asked to speak about the Hague Judgments Convention. Sorry, I go too far. Hold on.
No,
okay, I got it. Yes. All right. So the judgment project was to address the problems of, first, territorial limitations of judgments of domestic courts in respect of cross-border subject matter. Because a domestic court may assert jurisdiction over a transnational dispute, but its judgment will be limited in value if the judgment debtor or their assets is located outside of its territorial jurisdiction. The second problem that is addressed by the Judgments Project is that the private international law applicable to recognition and enforcement of foreign judgments differs from country to country. The basic premise of the Judgment Convention is that, first, contracting parties are obliged to recognize and enforce the foreign judgments of courts of other contracting parties. Second, contracting parties may only refuse to recognize or enforce those judgments on grounds specified in the Convention. The Judgments Convention applies to foreign judgments on, among others, employment, consumer contracts, physical injuries, right in rem. But the Judgments Convention does not apply to foreign judgments on family matters, wills and succession, defamation, intellectual property. The Convention sets out a list of bases for recognition and enforcement which relate to the jurisdiction of the foreign court that produced the foreign judgments. For example, the defendant has expressly consented to the jurisdiction of that foreign court, or the defendant was habitually resident in the state of the court of origin. Pursuant to the Convention, foreign judgment that ruled on rights in rem in immovable property is eligible for recognition and enforcement only if the judgment was given by a court of the state where the property is situated. The Convention also sets out grounds on which requested courts may refuse to recognize or enforce foreign judgment. One of the grounds for refusal is if a foreign judgment is made by a court other than the one chosen by the parties in their choice of court agreement. It shall be noted that the Judgment Convention will enter into force in September next year. Here is the situation of the enforcement of foreign judgments among ASEAN member states. ASEAN is the acronym of Association of the Southeast Asian Nations, as reported by the ASEAN Business Law Institute. If we see here, foreign judgments from other ASEAN countries cannot be enforced in Indonesia. But Indonesian judgment might be recognized and enforced in some other ASEAN states. To date, no ASEAN member states have ratified the 2019 Hague Judgments Convention. Thus, the enforcement of judgments among the ASEAN member states depends on the individual laws of each state. Pursuant to Indonesian law, foreign judgments cannot be enforced in Indonesia, except in the matters of maritime general average. And vice versa, Indonesian judgments are not supposed to be enforced outside of Indonesia according to Article 431 of the Civil Procedure Code. However, based on the legal doctrine, recognition should be given to foreign judgments that are not condemnatory in nature, meaning that the declaratory and constitutive foreign judgments, for example, as the ones I wrote in my presentation, will be recognized in Indonesia. In the near future, the Bill of Civil Procedure Code that will amend the Colonial Code has a provision that allows foreign judgments to be enforced in Indonesia as long as the judgments are made in the states that have bilateral or multilateral agreements with Indonesia on the recognition and enforcement of foreign judgments, such as the Hcch Judgments Convention. Thank you for your attention.
Thank you, Professor. Thank you for the taking us through the key provisions of the Judgments Convention. We'll certainly come to a few points in later during our panel discussion, including, for example, the point that you mentioned that the Bill of Civil Procedure Code would give possibility for the accession to the Judgments Convention. So we'll talk about that later. Last but certainly not the least, I shall introduce Professor Hcch, who will share with his views about the ongoing jurisdiction project. Professor He is a professor of international law at Peking University Law School. He is now serving as the Deputy Secretary General of China Society of Private International Law and the Chairman of Peking University International Economic Institute. Professor He has extensive experience in negotiations of multilateral treaties and international instruments, including in particular the Judgments Convention and the ongoing jurisdiction project. So Professor He, please.
Thanks, Chair. I would like to play the PowerPoint slides by myself, firstly. First, I sincerely appreciate Professor Zhao Yun inviting me to this important conference. I'm really grateful that I can't attend the conference in person. Today, my speech will focus on the negotiations of the Hague jurisdiction project. Sorry, I can't control the. Okay, that's good. My remarks consist of 4 parts. First, introduction to a case. And second, fundamental rules to address parallel proceedings. And third, negotiations of the Hague project and its new framework. Finally, my brief comments. Now I come to my first part. In 2021, the case Oppo versus Siswell International, a very influential case on antitrust in Chinese courts. In this case, Siswell raised an objection to the jurisdiction of the Guangzhou Intellectual Property Court, alleging that it had brought proceedings in the English, Dutch, and Italian courts. So the claims raised by Oppo should be heard in an English court. In this case, you can find only one dispute, which, however, involve 4 actions relating to 4 states respectively. In this case, we can also find each state has its business to access jurisdiction. China is the place where Oppo is domiciled and its principal place of business. And Italy is the place where Siswell is domiciled and its principal place of business. As for the UK, it is not only a place of business for the 2 parties, but also one of the IP holders' favorite firm. For the cases similar to Oppo, people may ask why there are so many actions over one dispute. I think we can list at least 3 reasons. First, the litigation strategy and protection of interest vary from party to party. Second, the same dispute in different national courts may potentially have different substantial outcomes. And third, diverse jurisdictional bases can provide sufficient grounds for national courts to hear a case. Thus, it seems inevitable for the occurrence of parallel proceedings. However, the parallel proceedings will waste judicial resources, potentially result in conflicting judgments and cause competition for jurisdiction. Therefore, international community needs to coordinate jurisdiction and to address parallel proceedings. Now I continue to the second part, fundamental rules to address parallel proceedings. There are 2 fundamental systems, first in-time rule and the bottom firm approach. The former is like European unions and the latter such as United States. The first in-time rules means the court first ceased proceeds with the action and other courts state their proceedings or dismiss the case. I use 3 words to describe the advantages of the first in-time rule: simple, efficiency, and certain. And the disadvantage of first in-time rule is also very clear, rigid, leading to tactical litigations, and also lack consideration on its relationship with mediation. So some delegates have some concerns about the first in-time rule. As for bottom firm approach, which come from firm-line convenience, the advantage of this approach is flexible and no need to consider jurisdiction. The disadvantage of this approach is also flexible, so that it does not fully address parallel proceedings. And the facts to be considered are complex, and the approach to determine the bad form varies from state to state. So from the preceding presentation, you can find there are 2 fundamental approaches to address parallel proceedings, which also means there is a huge disagreement on this issue. Of course, we have discussed other approaches such as prognosis of regulation approach in the Hague meetings, but it can be only an option, not a fundamental approach. Now I turn to the third part, negotiation of the Hague jurisdiction project and its new framework. In fact, the Hague Conference on Private International Law has worked in this field for a long time. In 1992, the Hague Conference commenced its work on jurisdiction. They worked for the first 10 years, but failed in 2001 diplomatic conference. In 2005, they succeeded in jurisdiction by agreement to reach the choice of court convention. In 2019, they succeeded in indirect jurisdiction to reach the judgment convention. So far, they have concluded the Convention on Service Abroad, taking of evidence and the choice of court in the judgment and so on. So I think jurisdiction should be the final fortress to overcome. Concerning the jurisdiction project, the Hague Conference organized 5 expert group meetings from 2012 to 2021. Then the project ended into a working group. In March 2021, the Council on General Affairs and Policy mandated the working group 3 objects. The first, to develop draft provisions on matters relating to jurisdiction in civil commercial matters. And second, to proceed in an inclusive and holistic manner with an initial focus on developing binding rules for concurrent proceedings. And third, to explore how flexible mechanism for judicial coordination and cooperation can support the operation of any future instrument. And after that, the working group had held 3 meetings and achieved certain matters. In February this year, the second working group reached a new framework for solving parallel proceedings, which is compound solutions. I will give more details of this new framework below. After parallel proceedings occurred, each court should determine whether it has a connection and whether other court has a connection. Then the first step comes. The first step is to find whether one of the courts has an exclusive connection. If yes, the court which has exclusive connection shall proceed with the case. Other courts shall suspend or dismiss the case. If no, come to the second step. The second step is to identify the type of case. If only one court has a connection under the instrument, please note the left section. The court with the connection proceeds and the other courts suspend or dismiss the case. If no courts has a connection under the instruments, the right part, each court may proceed with the case and suspend the proceedings under international law. If more than one court has a connection on the instrument, then the third step follows. The third step is to find whether the parties have chosen one of the courts. If yes, the chosen court should proceed with the case. The other courts suspend or dismiss the case. If no, the fourth step follows. The fourth step is to consider whether the proceedings in the court second sitting started within a reasonable time frame. If answer is no, for example, if the court first sitting has heard the case for 6 months and will render the judgment soon, at this time the court second sitting just commence its proceedings. So in such a case, the court first sitting should proceed with the case whether it is a more appropriate court. But if answer is yes, then the fifth step follows. In the fifth step, the process of the disputes leads to determine whether the same court is the more appropriate form through communication mechanism. If yes, the one court is considered more appropriate than the others, the more appropriate court proceeds. If no, which means that both courts consider themselves to be more appropriate. So in such a case, the first in-time rule applies. So far, this is the whole new framework. Now I come to my brief comment. China is a major country, especially in the adjudication of cases. From these slides, you can find that each year, China courts concludes a large number of foreign-related cases. There should be some cases on parallel proceedings involving foreign states. So in my view, the Hague jurisdiction projects will be an important reference for Chinese courts to deal with parallel proceedings in future. That's all for my speech. Thank you very much.
Thank you very much, Professor Ha. So it's clear that the working group has been making progress, and I understand that the group has just met last month or so, and obviously we'll meet again. There are, of course, some outstanding issues, and we'll, of course, come to them during our panel discussion. Thank you. So, professors, I think we're still doing fine on time, so let's just get on to the panel discussion. Professors, all your helpful presentations have covered a lot of ground, explaining how the Trust of Court Convention, the Judgments Convention, and the Jurisdiction Project came about, and how what they seek to achieve. Could I begin the panel discussion by asking this? Professors, could you give a scenario or an example to illustrate how each of these conventions or projects could provide legal certainty and predictability to support transnational litigation? For example, how might OPPO be decided differently if some consensus were reached under the jurisdiction project? This is just an example. Thank you, Professor. Perhaps Professor Lee, would you like to take that first?
Yes. Yeah. Sorry. Suppose that a business user in the internet or the metaverse subscribes its platform service, and its terms of the use or the terms of service include a choice of court rule. If the business user and the international and the metaverse service provider are nationals of the choice of court convention, definitely the choice of court agreement is deemed to be exclusive. This is the typical example of the choice of court convention will be applied. But the weakness of this project, actually, it is not applicable to a consumer contract. That's the weakness. But in terms of as far as the business users are concerned, they're not the consumer. Definitely, this project will provide legal certainty and predictability to support transnational litigations. That's I can say here.
Thank you, Professor Lee. Maybe Professor Aviva, would you like to add anything? Thank you.
Thank you. With regard to the Judgments Convention, besides providing legal certainty, the Judgments Convention could also provide efficiency and ease of doing business in Indonesia particularly. According to the Ease of Doing Business Index by the World Bank in 2020, Indonesia ranked very low in the indicator of enforcing contract. So with the ever growing number of disputes faced by Indonesian courts, the Judgments Convention may reduce the inefficiency and high cost because Indonesian courts do not have to judge anew matters that have been settled in courts of the other contracting states, as long as all the criteria of recognition and judgments under the convention are met. Thank you.
Thank you. Professor Ha?
Thank you. I think the OPPO case can be a good example to illustrate the disadvantage of parallel proceedings, in which the parties can shall perform in different states. Also, just now I have mentioned there are two different approaches, first in-time rule and the battle form approach, which also means a huge disagreement among states. So far, no global convention deal with parallel proceedings, and no international instrument coordinate those two different approaches. So if a new instrument can be reached, and other states concerned ratify that instrument, there will be only one state to access jurisdiction. So it will provide certainty to support transnational litigation. Thanks, Chair.
Thank you all. So professors, my next question is this. The Choice of Court Convention was adopted in 2005 and entered into force in 2015. There are now over 30 contracting parties. Some have rectified it. China signed a convention in 2017 and has not yet rectified it. The Republic of Korea and Indonesia are not yet signatories to the convention. So, Professor Lee, in your opinion, what are the considerations that countries would have to take into account in deciding whether to adopt the convention? And in your view, what might be done to encourage even more countries to adopt the convention?
As far as the scope and the coverage of the conventions are concerned, it is not applicable to the consumer contract, employment contract, as there is intellectual property issues other than the copyright. So during the COVID-19 pandemic, the volume of the transaction in the internet or in the metaverse are increasing. However, many of its users are classified as consumers. So definitely it will hinder the viability of the choice court conventions in the internet or the metaverse. As far as the domestic law is concerned, for example, South Korea amended the Korean private international law in terms of the international jurisdiction covering even the family cases and the non-contentious cases, fully in keeping pace with the choice of court conventions. For the time being, I think we are in the line with the choice of court convention prior to adopting the choice of court conventions. It is a way to follow the international law. Thank you.
Thank you. So, Professor, you've just touched on the scope and coverage of the convention, and on this, the choice of court convention, of course, applies to exclusive choice of court agreements concluded in civil commercial matters. But it may also apply to non-exclusive choice of court agreements in accordance with the reciprocal declarations made by the contracting parties. So, maybe to Professor Lee and Professor Aviva, do you think? In your opinion, does this possible application to non-exclusive choice of court agreements create any issues in your jurisdictions?
So the Article 8, the paragraph 3 of the Korean private international law prescribes that the international jurisdiction designated by the agreement by the parties are presumed to be exclusive. In this context, South Korea does not need the application of non-exclusive choice of court agreement in accordance with the reciprocal declaration made by the contracting parties. That's my answer.
Professor Aviva, would you like to add anything?
Yes. I just want to remind all of us that to date, so far, there is no states parties to the choice of court convention that have used Article 22 declaration on the enforcement of non-exclusive choice of court agreements. Therefore, Article 22, as a matter of fact, has had no effect yet. And I, myself, will not recommend the Indonesian government to enter the Article 22 declaration. Thank you.
Thank you, Professor. I think you just sort of answered my next question in a way, because I was going to ask, there has been discussion that the Choice of Court Convention and the Judgments Convention have the potential of having the same impact as the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So I was going to ask Professor Afifa that do you think the Choice of Court Convention and the Judgment Convention can achieve for litigation what the New York Convention has secured for arbitration? And in my observation, I was thinking that because there is scope for declarations and exclusions provided for in the Judgments Convention, for example, a contracting state may refuse to have reciprocal relationship with another contracting state under Article 29. It would be it somehow would be important that the contracting states are restrained in resorting to such sort of declarations or exclusions. And so anyway, you've also just mentioned that, as a matter of fact, insofar as declarations that we've earlier touched on, haven't actually been used. So I'm just wondering, would there be anything that you would add to the questions that I've just asked? Can these two conventions achieve for litigation what the New York Convention has secured for arbitration?
Well, I hope so. I just want to tell all of you about the case of Indonesia. So what happened is that after Indonesia ratified the New York Convention in 1981, there was an opinion that foreign parties who were more powerful, usually were more powerful in terms of capital and technology, often dictated the content of the contracts with Indonesian parties, including the choice of forum. In this case, the foreign investor usually dictated that the choice of forum should direct to the foreign arbitration. So as a result, the Indonesian Supreme Court became cautious of foreign arbitral awards. So after Indonesia's accession in 1981 to the New York Convention, the Indonesian Supreme Court had refused to enforce foreign arbitral awards for 9 years and ordered lower courts to do the same. So to avoid repeating what happened to the New York Convention in Indonesia, Indonesian judiciary must be convinced that the accession to the Choice of Court Convention and the Judgments Convention will not cause the exodus of settlement of disputes from Indonesian jurisdiction to foreign courts, because that is not the objective of Indonesia joining the Choice of Court Convention and the Judgment Convention in the very first place. On the other hand, to prevent the exodus, foreign parties must also be convinced that Indonesian courts can provide efficiency and legal certainty in resolving their disputes with Indonesian parties. In other words, Indonesian courts must improve their performance that still low at the moment. That's all my answer. Thank you.
Thank you, Professor. Still on the Judgments Convention, the Judgment Convention provides for the minimum requirements for recognition and enforcement of foreign judgments, REJ, if I may just briefly call it. In that sense, it provides a floor rather than a ceiling in REJ. That means the convention does not prevent or limit the REJ under national law, bilateral, regional, or other international instruments. So indeed, the Judgments Convention provides helpful guidance in the context of Hong Kong and mainland. Guidance to Hong Kong's bilateral agreements with the mainland China on REJ. Whilst China is not yet a party to the Judgment Convention, the mainland China and the HKSAR have signed the arrangement on reciprocal recognition and enforcement of judgments in civil and commercial matters by the courts of the mainland and of the Hong Kong Special Administrative Region in 2019. That arrangement was modeled on the Judgments Convention, and such arrangement is reflected in a bill being considered by the Hong Kong legislature. The arrangement and the convention bear close resemblance in various aspects. For example, the jurisdictional filters and the grounds for reversal of recognition and enforcement. But also, as the Secretary for Justice has pointed out this morning, on the other hand, taking into account the practical needs and circumstances of the mainland China and Hong Kong, the arrangement also covers a broader scope than the convention, including intellectual property matters. For example, judgments on contractual disputes involving IP rights are covered. Judgments on tortious claims for infringement of IP rights are covered, except for infringement of certain patents. Sorry, I'm trying to lay a foundation, so my question comes now. So to all of you, what are your views on jurisdictions separately concluding bilateral REG arrangements which may go beyond the Judgments Convention? How can these bilateral arrangements contribute to the progressive harmonization of private international law in this area? Perhaps Professor Aviva?
About the harmonization?
Yes.
Okay.
Bilateral agreements.
Yeah, okay. First of all, the entry into force of the Judgments Convention, Choice of Court Convention, particularly the Judgments Convention itself next year, wouldn't impact the reform of Indonesian domestic law, unless Indonesia accedes to the convention, obviously. And then there must be a lot of preparations about that because how to harmonize because Indonesia is based on the civil law legal tradition. Then what I understand from the previous presentation that the two conventions actually is kind of the middle way, or harmonizing civil law and common law legal traditions, So we must also educate or re-educate the judges and all the parties that will involve when Indonesia accedes to these two conventions. That is my opinion. Thank you.
Thank you. Professor He?
Thanks, Chair. Thanks for your important question. Concerning bilateral arrangement, just now, I think a phenomenon emerging phenomenon called the spaghetti ball, which is an interesting phenomenon in international trade, where the increasing number of free trade agreements, especially bilateral free trade agreements, might slow down global trade liberalization. However, in regulation and enforcement of foreign judgment, I think bilateral arrangements will be beneficial to the global circulation of judgments in at least two ways. Covering more matters and lowering requirements of regulation and enforcement of judgments. I take China as an example. First, at the international level, the scope of bilateral treaties concluded by China and other countries covers more matters than the Judgments Convention. And so far, China has concluded 37 bilateral treaties. Among them, 32 include regulation and the enforcement of foreign judgments. Many matters are excluded by the Judgment Convention, but included in those bilateral treaties. Chinese courts have also recognized and enforced many foreign judgments in accordance with bilateral treaties. Second, at the interregional level, just now you mentioned the arrangement between the mainland and the Hong Kong Special Administrative Region also cover more matters than the Judgment Convention, especially including infringement of IP rights. So I think bilateral agreements will be beneficial to the global circulation of judgments, and also the arrangement between mainland and Hong Kong reflects the guidance value of the Judgment Convention. Chair.
Thank you, Professor Ha. Just one final question on Judgments Convention, Trust of Court Convention, and then we'll move on to Jurisdiction Project. Professor Lee, you mentioned earlier that you pointed out from your perspective, cross-referencing metaphors, that the fact that the Trust of Court agreements doesn't apply to consumer contracts could be a weakness. On the other hand, Professor Afiva, I note that the Judgments Convention excludes from its application, a number of subjects, as you've pointed out, including family law, insolvency, defamation, IP, certain antitrust matters. Do you think, on Judgments Convention, do you think this arrangement on the scope of the application of the convention would attract countries to adopt the convention, or do you think this might cause countries to pause and think before considering?
I think it has something to do with the jurisdiction filter, because if the consumer contract is concerned, actually the domestic mandatory rule will apply to the consumer contract. So I think domestic mandatory rules is a totally, I think, a lot different from the international mandatory rules. So it's very difficult to narrow down domestic mandatory rules in this perspective. That's my point.
I see. Thank you. Professor Afifa?
Yes, I think this arrangement on the scope of application of the Judgments Convention may attract countries to adopt the convention, I think. For example, the exclusion of judgments in family law would allow countries influenced by Sharia law not to enforce foreign judgments that are deemed incompatible with Sharia. Thank you.
Thank you. So, professors, I've been asked to end this session a little earlier than originally planned, so I think we have around 5 minutes left. So, could I just ask Professor Ha a question on Jurisdiction Project, and then we'll try to take 1 or 2 questions from the floor. I have this panel with me with the questions from the floor. Actually, not 5 minutes, just 3 minutes. I'll do my best. So, Professor Ha, about the unfinished business under the 2 conventions relating to direct jurisdiction. Now, of course, the major challenge is to tackle the question of parallel proceedings. And of course, you very helpfully in your presentation explained that parallel proceedings are inevitable, hence the need for a coordinated approach. So can I ask you this? Which of the approaches would you advocate? There is this civil law approach, the first-in-time approach with the advantage of certainty, but rigidity as the disadvantage. The common law approach being the forum non-convenient, the better forum approach, as you've articulated, has the advantage of flexibility and adaptability, but of course somehow lacks certainty and predictability. So which of these 2 approaches, or you would say some hybrid approach, you've mentioned very detailed, for example, a compound 5-step approach under the new framework. Thank you, Professor Ha.
Thank you for you. This is a really excellent question. This is also a fundamental issue to develop the new instrument. As I mentioned in my presentation, there are 2 different approaches in which they have advantages and disadvantages and cannot be directly adopted by the working group and the expert group. In fact, we have also discussed many hybrid approaches in order to find a way to reach a consensus. So far, the new framework, that is to say the 5 steps approach in my presentation, should be a preliminary result. The new framework contains multi-factors and diverse approaches such as exclusive jurisdiction, party autonomy, first-in-time rule, and more appropriate form. So just the first three factors provide certainty. The last one, more appropriate form, has flexibility. So moreover, it will also include jurisdiction basis and the cooperation, the communication mechanism. So I think after such a long deliberation, it is a good progress.
Thank you, Professor. Just somehow picking up from that, because we're on the work of the working group, there's actually a question from the floor. It is of course noted that the Hong Kong SAR participates in the discussion of the working group on jurisdiction as part of the Chinese delegation, and shares Hong Kong's common law system in the context of parallel proceedings, in particular on the Better Forum doctrine. So as you've also participated as part of China's the delegation, Professor, in your opinion, how useful it is to have both civil law and common law perspectives within the one delegation in taking forward the work of the group?
Thank you very much. It has been first, it has been a great pleasure to collaborate with the Hong Kong colleagues in the past negotiations. I can't describe how useful, but an example coming to my mind. I remember in 2019, the diplomatic session of the Judgment Convention. One of the hardest issue is antitrust. And four Chinese delegates, including one members from Hong Kong Justice of Department, worked together during lunch time, and at last we drafted the current Article 2 1P on antitrust, and accepted by the other delegations at that time. China's delegation usually is a big one, not only includes delegates from central part, but also includes those from Hong Kong SAR and Macau SAR. And as for the current Hague jurisdiction project, those different legal system and legal traditions should provide insights into those different approaches. So I think we believe we can contribute to the Hague project. Thanks, Chair.
Just one final question. The original intention was to harmonize all these issues through one single convention, but of course it turns out a chunk by chunk approach has to be taken, and with the two conventions building a solid foundation, and as Professor Hao describes it, the final fortress is in sight. So just, but on the other hand, perhaps one might ask, with the differences among the legal systems to be resolved, is it still necessary and possible to have an international instrument dealing with parallel proceedings? Do any of the professors, do you think, is it still desirable and feasible to have such a new international instrument? Professor Ha?
You mean I first?
Okay.
Professor, thank you for asking.
Yes, I started first. I think especially the cooperation and the coordination of the parallel proceedings among the national courts and the foreign courts in insolvency cases are viable. So I think we need to start in this regard. I think the Korean court is really active in the coordinating and the cooperating network with the other foreign insolvency courts. I think also we need to deal with anti-suit injunction in terms of the choice of court conventions. Otherwise, I think the parallel proceeding will not be reduced. So that's my point. Thank you.
Thank you.
In response to your question, Chair, I can give you two short facts. One is the questionnaire on parallel proceedings and related action, which was conducted by the Permanent Bureau in 2020. Almost all the states responded that it is necessary, desirable, and feasible to have a new international instrument. The second fact, short fact, is that the mandate of the Council on General Affairs and Policy in March 2021, the Council mandated the working group to develop binding rules on concurrent proceedings. So I think those two facts are a good illustration of the necessity, desirability, and the feasibility of the future instrument. So if we successfully develop the future instrument, I think the final fortress in the way of harmonizing jurisdiction matters will be conquered. Thanks, Chair.
Thank you. So I'm afraid time is running out. So thank you very much, professors, for all the insightful discussions. May I invite a big round of applause to the professors. So I hope we could meet in person on the next occasion. Thank you again. Until then, stay well. Thank you. Goodbye.
Thank you. Thank you, Mr. Tavares. And also thank you, three professors. Please remain where you are. And Mr. Clifford Tavares, also please be seated, remain seated, and look at our official photographer. Our three professors, Professor Lee, Professor Kuzumandara, and also Professor He. Please look into your camera. Yes. As physically here at our Hong Kong venue, we have photographers to capture this important moment together. It's definitely a comprehensive, interactive, and also insightful section for us. Once again, a big round of applause to Mr. Clifford Tavares, Professor Lee, Professor Kusumadara, and Professor He. Thank you so much. Thank you. What a productive and also interesting morning section we had today. And to conclude today's workshop, we are honored to have invited Professor Zhao Yun, representative of Hcch, the Regional Office for Asia and the Pacific, to deliver the closing remarks. Ladies and gentlemen, let's put our hands to welcome Professor Zhao.
Ladies and gentlemen, the 10th anniversary workshop has come to an end. It is my great pleasure to make concluding remarks. To begin with, I would like to express my gratitude to the Commissioner's Office of the People's Republic of China's Ministry of Foreign Affairs and the Department of Justice of the Hong Kong SAR government. Without your support, the workshop would not have been successful. I would also like to express my gratitude to all the speakers, the 6 speakers who have contributed so much, and we have lively discussions this morning. And also I would like to thank the 2 moderators for organizing the sessions and keeping everything under control. But most significantly, I would like to express my gratitude to all the participants who are able to join us today. We've gathered here today at this 10th anniversary workshop hosted by the Hcch and its regional office to share ideas and opinions on topics of mutual interest, to form connection with extraordinary people in the field, to reflect on what we've accomplished over the years, and most importantly, to facilitate cross-border litigation and dispute resolution. I'm delighted that despite our short time frame, we were able to achieve our goals. 10 years have passed since the official opening of the Hcch Regional Office for Asia and the Pacific in the Hong Kong SAR in December 2012. Many countries in the region have demonstrated their enthusiasm by offering contributions to the office in various ways. It plays an important role in promoting the work of the Hcch in the Asia and the Pacific region. Especially, China has played a pivotal role in helping to strengthen the interaction between the region and the Hcch. The idea of setting up a regional office in Hong Kong is to strengthen the presence of the Hcch and representation by establishing a regional office in Asia and the Pacific. With strong support from the Permanent Bureau and in collaboration with member states, we have been exploring the possibility of gaining more visibility and expanding our presence of the Hcch in our region by means of organizing various activities, including regional conferences, Asia Pacific Week, and webinars, etc. On this special occasion of the 10th anniversary workshop, we have the chance to discuss the promotion and implementation of the Hcch and its conventions in our region. We share this precious opportunity with representatives from different areas, different regions in Asia and the Pacific, to talk about the experience of how they deal with the important issues of dispute resolution, and also to talk about the digital era, what kind of methods that we can use to resolve the issues that arise. We feel content with all the sharings and discussions that we had today. All the good work that has been done about facilitating cooperation as a means to support transnational litigation, and all the hard work around legal certainty and predictability as a means to support transnational litigation. Ensuring the effective practical operation of a convention requires further work that Hcch will continue to do in the future. And I'm very grateful that through this workshop, government officials and scholars, as well as global legal practitioners, all contributed their joint efforts, and we heard a variety of views and opinions for which we are very grateful. I have the unique chance of learning the important role that has been played by the various Hcch conventions, in particular the 6 conventions this morning, which we have a lot of discussions. So I would like to explore the ways that we can join hands and deepen the collaboration, and we are looking forward to that. Finally, may I once again thank the great support of the Commissioner's Office of the China's Ministry of Foreign Affairs in Hong Kong SAR, the Department of Justice of the Hong Kong government, and the Permanent Bureau of the Hcch for this wonderful event. In addition, I would like to thank my colleagues for their hard work, and we look forward to your continued support to the regional office in the future. Thank you very much.
Thank you. Thank you so much, Professor Zhao. Please be seated. What a meaningful way to celebrate the 10th anniversary of Hcch ROAP. Ladies and gentlemen, the Hcch conventions supporting transnational litigation in civil or commercial matters, a workshop to celebrate the 10th anniversary of the regional office for Asia and the Pacific, has come to an end. On behalf of Hcch, we would like to thank all our wonderful speakers and moderators for your insightful exchanges, and thank you so much for attending this workshop and making it a successful one. We would also like to express our heartfelt gratitude to this workshop supporting organizers, Department of Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, and definitely also the supporting organizations of the Hong Kong Legal Week 2022, including the Asian Academy of International Law, the Hong Kong Bar Association, Law Asia, the Law Society of Hong Kong, and Invest Hong Kong. Before you leave, ladies and gentlemen, please do remember to take all your personal belongings with you, and also return the SI headsets at the entrance if you have taken one. And your feedback is important for us, so we do encourage everyone, please complete the event evaluation form by scanning the QR code located at the entrance. For online participants, you can simply fill out the online questionnaire when it pops up. Last but not the least, for those invited guests for the Hcch ROAP 10th Anniversary Luncheon, please kindly make your way to the front door and our staff will be holding a banner to escort you to our lunch venue. So ladies and gentlemen, thank you so much for joining us this morning and we hope everyone have a fruitful and wonderful afternoon. Thank you.